All right. Well, I want to welcome everyone into this webinar today with Vince Wilcox, Esquire. Vince is a long time, it's actually been someone who's had almost 40 years, I think, of experience in the music industry. I have gotten to know Vince uh, in the late 90s, early 2000s. We had an opportunity to work together at Provident Music Group. And back in the day, actually, it was three separate companies that we were looking to kind of merge into one. I remember at the time, and I was on the distribution side. I think Vince might have been as well. We had a great working relationship. Always admired Vince for his experience and input in many meetings that we were in. I was running the international department there at the time. It was a great time for me 20 years ago. So since then, Vince has, he can tell you a little bit more about himself and correct me if I'm inaccurate in some things, but Vince is a lawyer and works in the entertainment law side, music business attorney, also has a tenure at Trevecca Nazarene University as a professor there. Actually, my son is there right at this moment, and he is considering music business or the music industry in general. So he might be seeing Vince walking through the hallways there or down on campus. But Vince is just someone has brings a lot of wisdom and has taken that experience and wisdom and created written a book, which he'll be talking about, but also created a course and a curriculum that you can follow on your own. It's a really comprehensive curriculum for anyone who is a songwriter, but also artist, anything related to the music industry. I remember I read a book by a guy named Donald Passman a long time ago called How to Make It in the Music Industry or Music Business, or everything you need to know about the music business. Anyway, it was super valuable. This is the current new version of that. Really comprehensive, and Vince brings a lot of wisdom. So I just want to give you a couple of notes here before I bring Vince on. If you have a question, ask your question in the Q&A area. I'll be watching that while Vince is teaching and sharing, and then we'll have plenty of time for questions. So ask your questions as you hear them and as we discuss them. Go ahead and ask your questions, and I'll be monitoring that. So that will be kind of how we run this. It'll be an hour long. We'll finish around 1 o'clock Central Standard Time. So sit back, get comfortable, and let me bring on Vince Wilcox. Vince, welcome to the webinar today.
Okay, can you hear me now?
Yes.
Yay. Well, Eric, it is an honor to be with you and to be with the writing worship community. As Eric said, we've known each other for over 20 years. And my experience goes back beyond the 40 years I've been in Nashville working in the music business. Like many of you, I just love the power of a song. I love the transformative power. And as I became a Christian and began my walk in Christ, I could see how God could use this language of the Spirit to get into the deep places of our heart and encourage us, to challenge us, and to also give us a voice by which we might praise Him and build a community with other believers and have this wonderful transcendent thing where we're together lifting our voices, putting our spirits together and lifting those to the Lord, and then having the Lord actually minister back to us through the songs. And so what you do in terms of writing and singing and leading worship and artistry, that's a sacred thing. It's a transcendent thing. It's a holy thing. And so even though I'm in the business of monetizing music, I think I always want to start out by saying how important creating the new song is, bringing those to the Lord and encouraging you, whether you end up making a living in the music business or whether this is just an expression of your relationship with God and a way to share that with the community that God has put you in. Incredibly valid. Your validation does not come through a royalty check. It comes through God saying, well done, good and faithful servant. So I'm honored to be here with you. I do want to talk about monetization of copyrights of songs. And before I do that, just want to give you a little bit more of my background. Wrote, sang, performed throughout high school and college. Had no idea I could make a living in the music business. My wife and I moved to Nashville in 1979 for her to finish up her undergraduate degree. And here I was in Music City. And I thought, I've got to do this, to take that leap of faith and see if there's an opportunity for me to make a living. And I had my little songs and my little chords and my little guitar, and I played them for a lot of very competent producers, and they were very kind. But when I got to Nashville, I realized, that there's a whole competitive commercial environment, and there's lots of really, really good songs in Nashville, but you have to have commercially viable, really great songs for them to break through. And publishers, their responsibility, their stewardship is to find and develop great songs and great songwriters, and then exploit them in the most positive use of the word, to steward them in ways that will create impact for their shareholders, but also influence for the songs and as believers for the kingdom. So anyway, as Eric said, I was in sales, I was in marketing, I was an artist for 5 years, booked myself, promoted, did my own records, did 500 dates over those 5 years, ended up with 4 #1 Christian country singles back in the 90s. My music partner and I won the New Artist of the Year award with the Christian Country Music Association. So we had a good run at that. But then I realized that to make a living, I could still do music, still write. To make a living, I wanted to get back on the business side of things. So I eventually became an artist manager, a tour manager, and then went to law school. And so, that's where we are now. That's the last 40 some years of my life. And I'm honored to be sharing whatever experience and expertise I have, Eric, with you and your community. So before I launch into monetization of copyrights, any questions or comments that you wanted to make?
Well, first of all, I forgot about that. What was your band called?
It was Wilcox and Pardo.
Wilcox and
It's like
Pardo.
Brooks and Dunn, but not nearly as famous.
Hey, man, that's a good comparison.
Hey, you can check us out on Spotify. It was we had a lot of fun, and we had just a great opportunity to minister and challenge and encourage families. So
yeah,
it was good.
Yeah, that's awesome. I do have two questions, but we can answer these afterwards. But one was from Sarah. She says, I've written biblical choral anthems and 2 pipe organ processionals. Would appreciate recommendations of publishers for this.
Okay.
And then Cedric, who is a producer songwriter, says his main question is, should I set up an LLC? Wanting to take my songwriting and production to the level of being an independent pro. Should I make an LLC? How would I do that? And what is the least expensive way? We can talk about those now, or we can talk about those at the end. We can save those.
Let's hold those if we could.
Okay.
And I will be happy to respond to both of those and other questions as well.
Perfect. All right. Well, we'll take questions along the way, but we're going to talk about all the ways that you can monetize your songs today, right? So I'll mute and let you do the.
Okay. Well, the first thing to remember, and most of you know this, is that there are actually 2 different ownership interests in a song. There is the underlying composition, which the copyright law refers to as a musical work, and that's the unique arrangement of words and music and rhythm of the song. It's the underlying composition. And we often refer to that as the performing arts, a PA copyright. But then there is the recorded version of that song. And that unique recorded version is referred to as the sound recording copyright. And, the example I love to give is the song Yesterday that was written by Paul McCartney and was attributed to Lennon and McCartney because they had this unique relationship. They wanted to be the Rodgers and Hammerstein of their generation. And so they agreed early on that whatever percentage the other one wrote of any co-written song, they would agree to share the ownership and the authorship equally. And this particular song, Yesterday, All My Troubles Seem So Far Away, McCartney wrote the entire song, but it is attributed as a co-write. So the underlying composition for Yesterday was assigned to their publishing company, Northern Songs, back in the 60s. And so that is the musical work, the underlying composition, and that is a unique copyright. Then the Beatles recorded the song Yesterday, and that unique performance, the recorded performance, which was owned by EMI Capital, that is its own copyright, its own separate copyright. And not only did that song, was not only that song recorded by the Beatles, but in the 60s and 70s, that this song was covered over 800 times. It's one of the most covered songs in musical history. And every single one of those 800 covers has its own sound recording copyright. And so there's really two musical interests that are involved here. There is the interest of the songwriter and the publisher, and then there's the interest of the sound recording copyright owner, who may or may not be related to the songwriter and the publisher. So you need to keep those two things in mind. Primarily today, we're going to be talking about the ownership interests of the songwriter and the publisher. And but we'll also make reference to the sound recording copyright owner and artist master interest as well. And all those are separate legal interests of a song, of a recording. Okay, before we launch into the type of income opportunities, I also want to remind you, and most of you probably realize this, that with a song, there's the songwriter interest, and then there's the publisher interest. And unless and until the songwriter or songwriters assign ownership of the song to a third-party publisher, the songwriter is also the publisher of the song. So if you're a self-published, or if you're a songwriter, you're your own publisher, unless and until you assign it to a publishing company. A publishing company is not ASCAP, BMI, or CSAG. That's a different opportunity. That is the company that monitors and licenses the public performance opportunities for that song. And I talk to people sometimes and I'll say, do you have a publishing company? And they say, yes, I'm with ASCAP. And that's not exactly right. And we'll clarify that in just a moment. But anyway, you write a song, you co-write a song, and as such, if you are your own publisher, then when the royalty comes in, you realize the income from that song. But if there is a separate publisher, and even if you're your own publisher, you will technically get often two different royalty statements. You'll get a royalty paid to the songwriter, and you'll get a royalty paid to the publishing company. And so one of our questions was about setting up my own publishing company and an LLC, and we'll talk about that a little bit later. But yes, you're on the right track. I encourage songwriters to not try to rush out and find a publishing deal as quickly as possible. I encourage them to work on their catalogs, to start their own publishing company, to register their own songs with a performing rights organization. And then at some point in the future, if they've got 20, 30, 40 really commercially competitive songs, a publisher might be interested in signing them to a deal. But what a deal is basically you have to write exclusively for that publishing company for a set term. And usually it's a year plus a number of options, plus another 1-year option or 2-year options. And during those terms, you as the songwriter are obligated to deliver. There's actually a delivery requirement of a certain number of songs to that publisher during the term. So typically it might be 1 song a month. A 12-month term, you have to turn in 1 song. Well, that sounds easy. Well, what if you co-write? If you co-write, you're turning in half songs. So now instead of 12 songs, you have to turn in 24 songs. Let's say you write with 2 other writers. Now instead of 12 songs, you have to turn in 36 songs that the publisher has to agree to accept during that term. There are delivery requirements for a publishing deal, and then there are usually some kind of advances. For a young publisher, you might get a small advance or maybe a monthly draw, but they're going to give you an advance against future royalties. And so if you're an unproven writer, you may not actually get an advance or anything substantive at all. And then after you've proven yourself, then the publishing company typically will begin to give you advances, maybe give you a monthly draw in addition to that. But their responsibility is to get the song demoed and to go out and pitch it, to license the song, to collect the income that comes in from the song. And then typically publishers keep half the money for their work, and then they distribute the other half of the money to the writers. And so that's basically how publishers operate. So if you're your own publisher, the things we're going to talk about here in the next few minutes, you have to do yourself. If you are a songwriter signed to a publishing company, then the publisher's obligations to take care of these things. So I'm going to start with mechanical royalties. This is the most obvious kind of royalty. A mechanical royalty refers to whenever a song is mechanically reproduced in another format. So you can think of LPs and CDs and cassettes, and even technically now MP3s are covered under mechanical royalties. But if somebody wants to record your song, if Chris Tomlin wants to record your worship song, then his record company has to go to you or your publishing company or your administrator, the company that handles all the licensing and collection and payments, goes to your publishing company and says, I want to get a mechanical license to put your song on this Chris Tomlin record. And let's say you wrote the words and music to it because you're an awesome songwriter. Then every time a Chris Tomlin CD is manufactured and sold, then you are due 0.091 cents. That's what's called the statutory mechanical royalty for every reproduction. So mechanical royalties have to do with reproductions. With downloads, you're still getting 9.1 cents per download. Typically, that money comes into the publishing company. The publisher keeps their half and then divides the remaining 4.5 cents across all of the songwriters. And if there are multiple publishers, then the publishers have to share the publisher's royalty. Now, moving from physically manufactured product to downloaded product, we're now moving away from all that toward a strictly streaming scenario. And I'll talk about digital income here in a bit. But mechanical royalties are the income that are generated from the reproduction and distribution of your song. So that's a mechanical royalty. The second kind of royalty we alluded to earlier is called a public performance royalty. So every single time a song is played on the radio, you hear it on TV, you hear it in the mall, there's an elevator going on. Technically, the owners of the copyrighted work, the underlying composition, that musical work, are entitled to a royalty for the public use of that song. And this is ironic to me, even when a song is being streamed to individuals, maybe 1 million people can hear it individually, the fact that they can collectively enjoy a song makes that a public performance. So in the United States, we have 4, which is amazing, 4 public performing rights organizations referred to as PROs. 2 of them, ASCAP and BMI, are nonprofit entities, and anyone can join ASCAP or BMI. And to be honest with you, they basically provide the same services, and they're very, very competent. Then there are 2 for-profit performing rights organizations, CSAC and Global Rights Management. And CSAC and GMR, they actually require an invitation. So I don't know how you get one. Maybe you submit some information to them and they turn around and they invite you. Or if you're Bob Dylan, they come after you, like they did at CSAC. Bob Dylan's at CSAC, Taylor Swift's at CSAC. And actually CSAC has a great history with publishing faith-based music and bluegrass and Southern gospel as well. Where I'm going with that is any entity that uses music in its business, whether it's radio or streaming, whether it's a restaurant, whether it's an elevator, like I said, a mall, any entity that uses that actually has to go and pay an annual license fee to one of these 4, actually probably to all 4 of these performing rights organizations, because if they use any songs that are administered and affiliated with any of these 4, then they technically owe the performing rights organization that annual fee. And then what the PRO does, and this is mind-blowing, is the performing rights organization actually monitors the usage. So over-the-air radio, they literally have sensors in every market at every frequency all across America. And they are capturing every song that's being played, when it's being played, and what the theoretical audience for that song is, whether it's 4 o'clock in the afternoon during drive time or 4 o'clock in the morning when nobody's listening. And they take all that aggregated information, all the public performance income from concert venues that come in, television, any public performance thing, they take that and they put it in a very complicated algorithm. And then they turn around and they pay the publishers their apportioned part of that income, and they pay the songwriters directly from their apportioned part of that theoretical income that came in from all of those licenses from that previous quarter. So that's what performing rights licenses, performing rights royalties are. There's a third kind of income called synchronization license, and synchronization is what it seems to be. It's the synchronization of music in timed sync with images, and those images can be a series of photographs, that could be animations. More than likely, there's some kind of video or some kind of film. So if somebody wants to use your song for a commercial or even a video, and technically even YouTube, then the publishers of the song, not only the publisher of the song, but also the artist of the song. Remember, there's a sound recording copyright interest. Both of them are due income, or at least at the very minimum, you have to get permission from them to use the song. So let's say somebody loves your song and goes, hey, I want to use it in a Ford commercial for an SUV, okay? And someone's cut it. So Ford has to go to the publisher of the song and negotiate a synchronization license for the musical work, and then has to go to the company that owns the sound recording and negotiate a synchronization license too. So a properly executed synchronization license will involve both the sound recording copyright owner and the owner and owners of the underlying composition. Of course, it gets complicated when you have a number of publishers and a number of songwriters. But again, that's what these companies do. And so sync license can be, you can be a gratis sync license. They can get it for free, or they can charge $1 million, okay, for a song to be used in an international commercial or in the Olympics, let's say. And maybe that's just used internationally for a year, $500,000, $1 million. I think of songs like Start Me Up, the Rolling Stones. Microsoft used it for the launch of Windows. I think of songs that were used in the launch of the iPod. And again, a lot of licensing money, and there's a lot of opportunity for sync. And that also is used for television shows, like every song that's used on Grey's Anatomy, and they use tons of songs on Grey's Anatomy, has to be licensed through what's called the music supervisor. And typically, just to give you an idea, if the music supervisor has $4,000 to spend on a song, then usually half of that goes to the sound recording copyright owner, and the other half will go to the owners of the underlying composition, the publisher and the songwriter. So that's synchronization royalties. A fourth kind of income, and this is particularly important for people who are involved in worship music, is print music royalties, okay? This is a different kind of license to actually put the words and music of a song in either digital printed format or physical printed format. Requires a print music license. And again, that license is not from the sound recording copyright owner. So if it's a Chris Tomlin song, they're going to go to Chris Tomlin's publisher, Six Steps Records, and they're not going to go to his record label, because the sound recording doesn't have anything to do with the print music. It is the underlying composition. So they go to the publisher, and typically for a piece of sheet music, the publisher might make anywhere between, for printed sheet music, make anywhere between 10 and 15% maybe of what the retail price of the sheet music is. So if it's a octavo that sells for $2, there might be 30 cents in royalties involved in that. However, when you're referring to digitally downloaded music, it's a different thing because they're not manufacturing physical copies, they're not warehousing it, they're not shipping it, they're not touching it, they're not bringing it back in returns and refurbishing it and putting it back on the shelf. It's simply a digital download. Digital downloads of sheet music, typically, the publisher gets 50% of whatever the retail price of the music is. So that is printed music. Okay, we're going to go on to the big enchilada here for worship, the worship writers, and that is Christian Copyright Licensing International Income, CCLI. So I mentioned before about public performance royalties and said that a public performance requires a license. Well, yes and no. There are certain exemptions to that license. One is a public performance that is used in a regularly scheduled religious service or in a educational face-to-face setting does not require that a license be procured and that fees be paid to the owner of the underlying composition. So when a song is sung in church, there's no money due for the public performance of that song. Now, if they played a CD of the song in church, then technically there would be, but just people singing and playing, musicians, organists, guitarists, there is an exemption for the public performance of songs. But that is for the performance of songs, not for the display of the lyric or for the copying of the lyrics to be put in a bulletin. So several years ago, some churches were actually being sued for making unlicensed copies of lyrics of songs, projecting them. And so a former music minister said, hey, I've got a great idea. Why don't we start a central clearinghouse for publishers and churches? Because up to that point, each church would have to contact every publisher directly and get a license for every single song they projected or every single song they copied and typed in their bulletin. So CCLI was formed, and now CCLI represents, I want to say something like 30,000 publishers in North America, about 160,000 churches in North America subscribe to CCLI, not for the public performance of the songs, but to be able to project the lyrics on the wall and to make to print copies of the lyrics in their bulletin. And so CCLI now, what they do is they charge an annual license fee based upon the attendance of the church. They take that money, and then a certain number of churches every quarter have to report their actual song usage. And this is not unlike the Performing Rights Organization. Then based on that, they have a very complicated algorithm, and then they pay the publishers for CCLI. And then the publishers turn around and pay the songwriters. And for most church-based publishers and most Christian songwriters, CCLI is, in many cases, the single largest income opportunity for them. Again, not public performance, it's the projection, that's the right to public display, and the right to copy, which is a reproductive copy or reproductive right in the copyright law. CCLI also does some interesting things as well. They license online usage. They offer, which is a different license. They license rehearsal tracks and distribution of usage of film clips, and which are also intellectual property used in church services. So that's CCLI. I mentioned before about downloads and streaming. Digital income, digital transmission income, again, now more than ever, is a very significant part of being a good steward of your song. So there are three kinds of digital transmission income opportunities. And because we're talking about songs that are being heard digitally or downloaded digitally, again, it's the sound recording copyright owner and the interest of the owner of the musical work, the publisher. So these two are kind of connected to each other, and I'll kind of disconnect them along the way to kind of show you where everything is. So the first one we have already referred to is digital downloads. And digital downloads are, for all intents and purposes, the same as a physical copy of the CD. So with a physical CD, an artist label would be paid a royalty for the sound recording copyright, and then the artist would generate a royalty based on their deal with their label. And so typically a record label would put a deal together with an artist and say something like, we're going to give you 15% of the income. This is grossly simplified. You're going to make 15% artist royalty on whatever is sold from your record, okay? And so there's lots of other people who take money along the way, and we're not going to refer to those today, but an artist might make 15%. The label would make more than that. And then the label also would have to pay, or in this case, the publishing platform, the internet service provider, would have to pay a mechanical license for every song that was downloaded. Okay, so that's all monitored digitally. And so for all intents and purposes, downloads are like physical product. There's a mechanical royalty that's paid to the publisher. There's a license royalty for the sound recording that's paid to the label. Okay, that's number one, digital downloads. Number two is if digital downloads are like physical product, then non-interactive streaming, which is like Pandora or Sirius XM, non-interactive streaming, where you basically log in and maybe even you create your own radio station, or you listen to a pre-grouped or pre-algorithmed list of songs. You don't get to pick the song you want to listen to and listen to it indefinitely and infinitely. You pick the kind of songs you want to listen to, and a playlist is created for you. This is great for music discovery, but this is non-interactive. Non-interactive streaming is akin to public performance radio, right? Because you're not picking the song you want to listen to, but you're picking the station. And so for non-interactive streaming, the songwriter and publisher would receive public performance income through their PRO, just like they would if it was over the air. Now, we were talking about over the air playing. You hear a song on the radio, in your car. What's interesting is that if you hear a song, let's say Chris Tomlin, How Great Is Our God? Okay, so Chris Tomlin, Ed Cash wrote How Great Is Our God. So the publishers, Six Steps Records, they're going to make money every time that song is played, theoretically through the public performance income. But what's interesting is that Six Steps Records and Capital Christian Music Group that own the master, they don't make any money for the public performance of the sound recording, which is crazy, because it's, people are not tuning in to hear words and music. They're tuning in to hear Amy Grant, or they're tuning in to hear, Chris Tomlin. They're tuning in to hear that artist. But in the United States, artists and record labels actually don't make public performance income on over-the-air performances. We're part of a small number of countries: Iran, Somalia, North Korea, and the United States are, to my knowledge, the only 4 countries that don't pay the artist and the record labels for over the air. Well, there's actually, and there have been for the last 40, 50 years, bills in Congress to help rectify that, because certainly the artist and the label should make something every time the song is played over the air. When the internet got cranked up, as Congress was administrating that, they thought, this isn't that fair. Maybe we can make it fair for the artists and the labels with streamed music. And they did. They established a company, a nonprofit company called Sound Exchange, which actually monitors and licenses the use of the sound recording copyrights and pays the artists for streaming and for internet radio. So for Pandora, for non-interactive streaming and internet radio, the sound recording copyright owner makes money through Sound Exchange, the publishers and the songwriters make money through the performing rights organization. Now, let's go to the big one. The big one is interactive streaming. We have gone from when Eric and I worked at Provident, 99% of the revenue that came in was through the sale of recorded music in physical format. Now, more than 85, close to 90% of the recorded music revenue comes in through streaming, through digital streaming, okay? And so on-demand streaming continues to be a growth area the last 5 years, year after year growth. And so this is convoluted and very confusing how it's done, but there's a number of different ways that the publisher makes money through a pseudo mechanical royalty. there is a public performance aspect, and then the record label makes some money through their licenses with the internet service providers, and it's a mess. And if I could explain it any better than that, if anyone can explain it any better than that, I dare them to do that. But that's really, so if you look at your royalty statement from streaming, you'll go, I have no idea here. I just see 0.00012 cents. And the challenge with streaming is that the average stream generates 0.004 cents for the record label and probably 0.002 cents for the publisher, or less, significantly less for the publisher. It takes the record label about 1 million streams to generate $4,000 in record income. So that's the new environment we live in. Okay, so I don't want to discourage you there, but that's where we are. It's heading in a good direction. Year after year income for the publishers are going up. Year after year percentage of revenue for all these things is going up incrementally. So that's a very positive thing. Let me just stop there. I was going to talk about digital sampling, but that's a very minor thing. But so those are the main income streams for publishers, and as an aside, for artists. So hit it, Eric.
I can see why you teach this at Trevecca Nazarene because it would take an entire semester, I think, to unpack it all for students. And of course, a 3-year law degree to unpack.
Well, that doesn't hurt. But I mean, a lot of the stuff you can learn. Yay. I see Farouk is a graduate of Trevecca. Yeah. I think it's really important that even if you're not going to do all this yourself, to know how it's done and to know the difference between a PRO and CCLI income and what a mechanical royalty is. Just having that knowledge is incredibly empowering for a songwriter. And again, many of you may want to start your own publishing company. And I actually have a chapter, couple pages in the book about how to do that. It's not that hard to do.
Okay, so lots of good questions here. And I'm going in the Q&A area, by the way, is where I'm answering questions for everyone that's going to ask questions. You'll want to go in the Q&A area. I did see some questions and comments in the chat. I'll try to pull those out, but most of the time I'll be in the Q&A area. So let's go ahead and start with this question. Melanie asked about sync royalties. She says, sync goes half to the owner of the composition and half to the owner of the written work? She's trying to clarify that.
It's half to the owner of the underlying composition. That's the words in the music. Mm-hmm. And the other half goes to the owner of the sound recording copyright. Yeah. Okay, so the audio owner gets half of it historically. I mean, it's not cut and dry, but if the music supervisor, who's the person who wants to use the song in a commercial or in a TV show or in a movie, says, I've got $4,000 to spend with you. Typically, $2,000 will go to the master recording owner, and $2,000 will go to the publishers, who will then split.
It's not a clear cut half and half typically.
It is typically about half and half.
Okay.
Yeah.
Okay.
But
Very good.
either side could, play hardball
Hmm.
and ask for more. But typically it's split.
Yeah, and there's really no. Is there any kind of basis for deciding? No, there's not. It's
It's
just
it's
whatever the budget is.
it's
That's
whatever the budget
what it
is,
starts.
and
Mhm.
it's whatever the parties are willing to negotiate. And so, the downside is you don't want to necessarily be giving away your songs for free. The theoretical upside is if more people hear your song on a commercial or on Grey's Anatomy, it's going to give your song a higher profile. Whether that will actually convert monetarily at some point in the future is always very debatable. So,
Well, a current example was I remember The Weeknd had his song was playing leading up on every NFL game leading up to the Super Bowl. Uh, his big hit was playing every single time, and I'm sure they negotiated the NFL
yep.
or whatever the
They
network
probably
was.
went directly to the NFL. These performing rights organizations negotiate what are called non-exclusively. And
Mhm.
so if the NFL wants something, they can just go to the publisher directly. They don't have to work through the PRO.
Right, right. Okay, good question. I'll ask Melanie's question again for copy. Another question from Melanie for copywriting. I've only ever used Form SR to cover sound recording and written work. Is this okay?
Yes, it is. If you are the artist and the songwriter, you can use SR. If you are just a songwriter and you haven't done a recording, you can use the PA form. And actually, if you co-write with the same co-writer, you can actually register a collection of up to 10 songs by the same two co-writers, as long as the shares are the same. Register them for the same price. It's about $65 if I'm not mistaken. And then later on, you can turn around after you get your copyright certificate back, which might be, 7 to 10 months. You can turn around and do an amended registration and cross-reference all 10 songs through the copyright office for another $65. So for basically the cost of 2 songs, you can copyright 10 songs. And then just as an aside, copyright protection begins the moment you commit that song to some tangible replayable format. So you make a video of it, you type the lyrics on your computer, you do a little voice memo. At that moment, that's when copyright protection begins. So what copyright registration does is it formalizes it and gives you what's called prima facie evidence that you are the song's composer and rightful owner. So if there's ever a challenge to that, you can go to court and say, I have a certificate. They have to prove I'm not the author. They have to prove I'm not the owner. Additionally, registration will allow you to get what are called statutory damages if there is infringement. And the infringement, if someone infringes or if you infringe on somebody else's song, it's $750 to $30,000 per infringement. The courts are really going to crack down, which is why everybody's suing Katy Perry and different folks for alleged copyright infringement. But the penalty by statute can be anywhere between $750 and $30,000 per infringement. But those statutory damages are only available if you have registered. Additionally, you can get what are called attorney's fees. So the cost of your attorney prosecuting the case, you can potentially get that back when you register. But there are many, many big companies in Nashville now who only register their songs when they get cut by big artists, because the cost of registering it is so high. If they're generating, if they're generating 1,000 songs a year, they don't want to spend, $35,000 registering it. They'd rather wait till it gets cut, then they'll register it at that point, or not at all, because they've got some kind of proof that shows when it was created. So,
Right. Is the onus on the copyright owner to register those songs?
yes.
Or is it, yeah, it's always on the
Yeah.
publisher.
Right. And that's one of the things. But a publisher, I mean, if you sign with a publisher, you should ask them, are you going to register my songs with the Copyright Office? Because they don't technically have to do that. And
Right.
if they don't register, then they can still seek infringement, they go to court and show infringement. They're just not going to get statutory damages. And again, having that copyright registration is prima facie evidence. It gives you the high ground if there's ever an infringement. It's no guarantee. It's not irrefutable evidence.
Right.
It's on its face evidence.
I remember when I was younger and I initially started, I would run to register all my songs. And what I advise now is I would not, do that unless you have a lot of songs at the same time to save the money.
Yep.
Right. And you just correct me if I'm wrong, but don't go running because you have proof digitally, yeah, because you've recorded it.
Right. And then on top of that, a lot of people used to do what are called poor man's copyrights, where they'd send a certified letter to themselves with a digital copy or the lyrics, and they'd seal it, and that would show proof of ownership at a certain time. But it doesn't give you the same copyright protection that registration does, but that doesn't give you any more evidence than a digital file would.
Okay. A couple of related questions, and we'll get to all of your questions today, guys, so don't worry about it. But just sticking on this theme, Christiana says, does registration with a PRO hold up in court if publisher did not copyright with the U.S. office? Does registration with a PRO?
No. The PRO, I mean, you could use registration with the PRO as evidence of when the song was the song was at least created by you on this date.
Mm-hmm.
But if someone else has registered the song, has copywritten the song, then they have prima facie evidence, and that the PRO does not trump the copyright certificate.
Okay, good. One other question that I want to mention your course and then continue going to these questions. Christiana says, is it true that claimant with most dollars lawyers wins a copyright case versus who actually owns the copyright? What is the average cost and time of a copyright case?
Okay, this is a great question. A competent entertainment attorney, and if I were ever to go to court, I would probably hire another experienced entertainment attorney to go to court in copyright things, because the amount of detail and experience, I mean, literally, I would hire a firm with years and years of experience doing hundreds of these cases. And I wouldn't just hire my cousin Vinny, the lawyer. I would, having an experienced attorney is extremely helpful. Now, that said, an experienced copyright attorney, intellectual property attorney, is going to run between $200 and $400 an hour. Okay. So it's very expensive to prosecute or defend a case like this. Now, registering your song with the Copyright Office does make you eligible for attorney's fees if the court rules in your favor. And so, but that's not guaranteed. It just makes you eligible for them. So, yes, to some degree, the party with the most money who can afford to go to court and stay there the longest will have a disproportionate advantage. Now, that said, the copyright law there is to support, especially with respect to these very high damage, statutory damage awards of $750,000 to $30,000 per infringement. They are designed to level the playing field and give the small songwriter, the small publisher, put the law on their side, and to give them an advantage, knowing that if the other company loses, they're going to be subject to those. And if the infringement is egregious and ongoing, it can be as much as $200,000 per episode. So. Mm-hmm. So yes, the legal system is, as an attorney, regrettably, it is those with the most money have the most advantage. But the law does provide opportunity for the underdog to level the playing field with, that's not just the judge and the jury are not going to care about the attorney, how much the attorney is being paid. They're going to go by what the law says.
Right. Okay. Very good. So I want to just share my screen here. We're going to pause for a second. There's a lot of great questions still left to be answered, and I will get to those. But I want to just take a couple of minutes to share my screen and share what you're offering to everybody today as well, because I think this is really, really important. Great uh, opportunity to talk to a music business attorney and talking about the law and specifically how the music business works. You pointed out your book real quick. You want to show that? You can find that on Amazon. Show that on your screen. Yeah, how to make a living in the music business.
Only $30 versus $200 an hour for my legal opinion. So.
And also, if you want to dive into detail about every element of the book, you go to musicbusinessbasics.com and you can use the coupon code just for us, worship10. And you want to tell us about these courses, this curriculum you've created?
Yes, thank you. You can see there's 3 modules. The first is on making and marketing records. The second is probably going to be more interesting to you. That's songwriting and publishing. And the third is managing and booking artists. So as a self-managed and self-booked and self-promoted artist, I've put as much experience and expertise into each one of these as possible. But each individual module goes for $399. There are about 4 to 5 hours of video instruction on each one, and then another probably 4 or 5 hours of interviews with industry professionals where, for example, in songwriting and publishing, I talk to songwriters, I talk to publishers, I talk to administrators, I talk to creative directors, and let them not only unpack their knowledge and show you how it works in a real life setting, but also they share their journey. You've all probably figured out there's no A, B, C, 1, 2, 3 step to success in anything, much less the music business. And so there's 10% off any one of these, or collectively. The entire course goes for $995, and you would get 10% off that. So a savings of $200 plus another 10% off that, dropping it down to $900 for the whole thing. So anyway, at the very minimum, I'd love to encourage all of you to go to musicbusinessbasics.com. Please register for my newsletter. I would love to send you something every month about what's new in music business. Secondly, there's a free 24-hour course preview where you can preview all the courses, or any course for that matter, for 24 hours before you buy. And then there's a 30-day money-back guarantee on it as long as you haven't watched or consumed more than 50% of any course. I'll give you all your money back within 30 days if you're not satisfied with the experience that you have. So along the way, there's, oh gosh, probably 100 little videos in each one of these courses, anywhere between 2 minutes and 10 minutes. And then after every 2 or 3 video clips, we stop and there's a little multiple choice test to kind of reinforce the principles that were presented in the previous section. So anyway,
yeah. It is
go ahead.
It's a full music business education, I think.
Well, it's 25 hours all in. I would say, in defense of Trevecca and any undergraduate program, you spend about 4,800 hours in college. And so this is the highlights of just the music business, just 25. So it's not a substitute, but certainly it will give you a lot of knowledge, and knowledge is power. So
that's right. And the book is just a great resource guide as well, too, just to kind of have on hand if you want to just quickly reference some things and, oh, okay, this is the way the law works with copyrights in this area. So Music Business Basics, sign up for the newsletter if you can. And
the book is called How to Make a Living in the Music Business.
That's right. How to Make a Living in the Music Business.
And it's on Kindle, and it's also available directly in paperback format. So
and audio too, right? Or no?
I'm still working on the audio.
Oh, okay. Can't do it all, right?
Yeah, but I will eventually. But I want to get back to one of the first questions about starting an LLC for your business. Can you see me? Yeah. Starting an LLC for your business. There are different kinds of business formation. A limited liability corporation is one of the easiest ones. You do so by going to your Secretary of State, and you can look on your Secretary of State's website and check out the name of the company that you want to register as your LLC. So if you wanted to start Eric Nordoff Music LLC, you could go in there and type it, and you could see if that, and there probably no one has that name for their company. So you're good to go. And again, I would encourage you to check out, to Google names as well. And maybe even if it's a music company, you can go onto the sites of ASCAP, BMI, and CSAC and go through their catalogs and make sure your catalog name is not too close to what to something that's already out there. In fact, with BMI and ASCAP, one of the things you do when you sign up for them is you give them 3 different names in priority order, and then they go through their catalog and they see if there's anything that's like that. So finding the name of your company is really an important step. Then registering as an LLC. After you register as an LLC, you also go on to irs.gov and get yourself an employee identification number, which you would need to, you'll want that so that you can distinguish your business separately from working off of your Social Security number. It doesn't cost you anything to do that. And of course, an EIN is important for getting a bank account and then getting business licenses. And so in my book, I talk about 12 steps to starting your own publishing company, and hopefully you'll have a chance to look at that. But it's not that hard. You have to get your business name, you get your EIN, you at the same time you're doing that, you get your publishing company name with your PRO. Then I would say make sure you I would encourage you to get a post office box, because you're going to move and you don't want those checks to get lost. I've moved, I've lost checks. Years later, I'm like, hey, look, there's an $800 check. It finally found me. So PO boxes are very helpful. And then I would not suggest just going out and Googling forms. I would really suggest going to a entertainment attorney, experienced entertainment attorney, and getting some forms. If you want to start a publishing company, you want to sign other artists, songwriters, sign songs, sign catalogs, is to make an initial investment in some basic forms with them, because the business environment is constantly changing, and you don't want to just pull something off the internet thinking that it's going to be comprehensive or relevant or up to date, and it may not be. And my suggestion about working with an entertainment attorney is, if it will involve a significant amount of money or time, then that's where I would encourage you to look for an entertainment attorney. But I will say, and I know this sounds self-aggrandizing, but this book's $30, and it will help you develop a vocabulary for music business that will help you have conversations with your $200 or $300 an hour attorney, where he or she is not explaining things to you that you could already know. And this book could save you a lot of money in that sense. It's not legal advice, but it's giving you the principles and the concepts and the precepts that you'll need to be successful.
Very smart. Read the book ahead of time. Know the terminology. Know what you're asking for. I spent about $1,000 recently to set up, get all the templates for my single song agreements that I proposed to all of these writers that we're working with, and it was and a couple of other contracts that we could use as templates for future agreements. And it was a one-time investment, but it was well worth it, especially for you, Cedric, if you're going to invest and become a pro, an independent professional publisher. That's what I would recommend you do. So, okay, Sarah mentioned this as kind of switching topics, but it was the first question. I wanted to make sure we answer it. She says she's written biblical choral anthems and 2 pipe organ processionals. Would appreciate recommendations of publishers for this genre.
Okay, so if you're going to pitch something to an existing publisher, they're going to want to hear at least a rudimentary demo of it. Just sending them the sheet music that they're going to have to play off of. I mean, you could do that, but most of them will want to actually hear something. And so to produce, just literally right off your keyboard is going to be fine for that kind of thing. And then if you're able to send the notation in Sibelius or Finale or something like that, or actually just a PDF of it is extremely helpful. St. James Music Press is a great little company that sells sacred music. You could look them up. You could also look up Yuba Latte Music, and I think it's Alfred Music. They're related to each other. They do a lot of good choral stuff. You could certainly just Google sacred music, Shawnee Press, Google pipe organ music, and sometimes, to be honest with you, they don't take unsolicited material, because then people later on say, well, I sent that to you and then you kind of ripped me off and now I'm going to sue you for infringement. So, you'll just have to contact them and ask them if you can send them some pieces. And I would send no more than 3 at a time, because I've been doing this with my publishing company for years. And if I get more than 3, my eyes roll back in my head.
Someone, Christian, recommended GIA Inc.
Yeah.
Is an option for sacred choral music publication too.
Very good.
Good stuff.
GIA is really good. Yeah.
Good to hear. Okay, great. A few more questions here. Jolie asked, will PROs give royalties for years past if your song has been out there without a PRO license?
No.
Yeah, that's an unfortunate thing. We learned that ourselves.
Yeah.
We lost probably 7 or 8 years of Your Great Name income from that, because we assumed that our PRO was doing the work on that to collect. And we did have a PRO. It's a little different issue, because we did have a PRO, but we didn't realize that we were responsible for sending concert data and information to our PRO.
Right. Another thing to keep in mind is, if you are your own publisher, then your PRO will not send information to CCLI in terms of getting your songs registered over there. So you're going to have to basically contact CCLI and say, here's my publishing company. I need the protocol to send the music to them so that they can begin tracking that. They don't. You're right. There's lots of disconnects between publishers and PROs and collection agencies and licensing agencies. And so a good publisher is going to make sure all those connections are made.
It's best to ask the questions and do your due diligence, knowing what you know, and not ask the question. That's the big message you can.
And don't ever feel bad about asking the question, and they're more than happy to help you. And the more informed you are, the better client you'll be for them. So
so a couple of covers questions. Can we do online covers as an artist without paying royalties or copyright infringement? And maybe how do you do that?
Okay, so we're talking about YouTube or Facebook, I'm sure, at this point. So theoretically, anytime you sync or online, if you're doing, are you talking about Spotify or
I think she might be. Let's just assume YouTube, Facebook, Instagram, TikTok.
Okay.
Anything like that.
Theoretically, anytime you use somebody else's intellectual property, you're supposed to get their permission. But functionally, it's pretty much impossible. So what YouTube has is a deal with existing publishers. An existing publisher, if they've got a deal with an existing publisher and then they identify the song as from that existing publisher, then a portion of the advertising revenue, or if it's a subscription revenue like Vivo, YouTube Vivo, a portion of that revenue will be redirected to the publisher, who will then distribute some of that to the songwriter. Okay, so but those are usually pretty major publishers. So Taylor, there's some artists like Taylor Swift who don't want their sound recordings used, but maybe their publisher would feel fine with the underlying composition being used, as long as they're going to make some money off of it. So again, there's kind of this deal it's not an under the table deal. It's really a very practical way for publishers to get paid from their songs being used without them theoretically being licensed. So can a publisher contact YouTube and say, no, we don't want you to use that song, take it down? Yes, they can do that. But functionally, they're probably going to say, fine, as long as we're going to make some money off it. We'd rather have something than nothing.
Right. Good. Chantel asks this: when it comes to legal purposes for copywriting, when you write a song and it includes a song that has already been published, what's the process and how do you go about it without getting charged or sued? For example, now this is the example she gives, which is a public domain song. For example, writing an arrangement of Amazing Grace, but having some of your own lyrics within the original arrangement.
Okay. Well, there you bring up two issues. One is the issue of what are called derivative works. And derivative works are one of the 5 or 6 bundle of rights that the copyright owner has for a song. So if you want to take a song that is currently protected by copyright, copyrights are in effect for the life of the songwriter plus 70 years. Okay. So after the life of the songwriter, all the life of the songwriter, and 70 years go past, then it falls into the public domain. If it is currently a song that's owned by someone, you actually have to go to them and get permission, and they will probably require approval of the song. They'll probably require co-ownership of the song, and they're going to want some copyright interest in something that they own. They're not just going to give you the rights to use part of their song. Now, with respect to a song that is in the public domain, like Amazing Grace, and it's a good example, Chris Tomlin wrote a derivative work from John Newton's Amazing Grace called Amazing Grace, My Chains Are Gone. It was used in the film Amazing Grace, great film, by the way. And so what he does is because it's in the public domain, all he has to do is his publisher just attributes the co-right to John Newton, but there are no, that's the extent of the obligation. You don't want to say you wrote Amazing Grace because you didn't, but if you want to add to it or adapt it, a song that's in public domain, you just simply put them as one of the co-writers, but they are not co-owners or co-publishers of the song. And so you're good to go on that. Well, can't hear you.
Sorry. Christiana said, is it true that musical score lead sheet with lyrics and melody hold up best in court versus digital MP3?
Well, it used to be, prior to the United States becoming a signatory to the Berne Convention, which is an international treaty about intellectual property protection, it used to be that in order for you to have copyright protection, you would have to have a lead sheet. It registered with the Copyright Office. I think that was, I can't remember when, maybe 74, 78, when we signed with the Berne Convention. Prior to that, you actually had to send a lead sheet in. That was your proof of ownership and creation. Mm-hmm. So now you don't. So I think an MP3 would be equally evidential.
Yeah. Okay. All right. Just 3 more questions, guys, and we're going to wrap this up. Thanks for staying a little bit longer, Vince. Hope this is okay.
Oh, no, this is a blast. This is like, beat the clock.
I know.
Stump the attorney.
Linda asked this: how do you know who is singing your songs out in public? Like, for instance, Your Great Name was so popular. How would you know who is singing it out?
Well, you probably wouldn't, okay? But here's where your opportunity would come. One is if somebody recorded it. If somebody records it, they have to get a license to use the song. And often they'll either go to the publisher, to your administrator, or potentially they will go to the Harry Fox Agency, which is a third-party agent that works with companies to handle mechanical licenses for recordings. Okay, so there has, and so what will happen is you'll get a royalty report from the Harry Fox Agency or whoever your publisher is saying that somebody used it as a mechanical license. So that's that part. With respect to CCLI, a song like Your Great Name, churches will report their usage. They'll report the size of the congregation, and then you'll get a report that shows, how much income was generated, but you won't know who sang it in which church. So it goes out. You won't know who's doing it unless they're recording it, in which case there will be a license and a royalty trail.
And then also on the performance royalty side too, performing rights organizations,
Yes. Yeah.
they'll also do the collection and
Yeah. And you'll see for the recording of this song by this artist and the recording of that song by that artist. Yes. Good. Good.
We initially that was kind of our first experience with was Your Great Name. I mean, that was the first time we had. I think eventually, I think now we have about 50 different versions out there or more of that song, at least just on the streaming side. And there were times when we needed to let the administrator know, hey, this person recorded it. We needed to kind of cross-reference to make sure that they requested a license to record that song.
Right. Right.
And that was a good exercise for us to go through to do our own due diligence to make sure that our administrator, which is music services, had a license on hand for that. Because we were the publisher on it.
And it's probably a good idea to actually look at the royalty reports. I had a friend of mine send me a royalty report the other day. She's got a derivative work of Silent Night. Okay. And our administrators had sent back a royalty report that said that Foreigner had cut it on their Christmas record. I'm like, no, I'm pretty sure Foreigner didn't cut it on the Christmas record. So, yeah. So it is a very imperfect process. It's better than it was. It will be getting better, but it's always a good idea to look at your royalty reports, figure out how to read them. Whether you talk to your publisher or, I'm sure you could even get your PRO to say, hey, can you help me understand how to read right. this? I mean, they probably have some online tutorials on stuff. Just understanding how things work will make your life so much better. And you won't miss opportunities just because you didn't know what you didn't know.
Right, right. Good stuff. 2 more questions and then we'll run, guys. I know everyone's needing to go. Frankie asks, what are other outlets for Christian radio besides K-Love, Air One, Sirius XM, The Message, The Dove? I mean, there are a lot of options.
Well, yeah. Well, here's the challenge with radio. When you and I were growing up, we had what was called a top 40 format. And what that right. meant was there were 40 songs in current rotation at any given point. Radio stations basically have 3 different ways of characterizing music. Current, which are the new songs, recurrent, which are the previously new songs, and then gold or classic. Okay. Mm-hmm. And what radio station programmers do is they actually decide how many current, recurrent, and classic songs are going to be played every hour on the clock. And so different hours of the day, they may have a different mix. Okay. So when you and I were growing up, there were 40 songs in current rotation. Well, what radio stations did, I mean, they're both nonprofit and for-profit stations, they want to get ears either for advertisers or for donors. So what they did was they did research and they found out from their listeners want to hear their favorite songs by their favorite artists more frequently, which meant instead of having a top 40 format like we used to have, today, most professionally run stations run 12 to 14 songs in current format. And at any given point, there's probably another 50 or 60 songs that established record labels with established and new artists are trying to push into the 1 to 2 new songs that station might add that month. Okay. So again, it's just the reality we live in. Getting your song played at radio is really the game of major labels. You can get your song probably played on a local station. Maybe a national public radio station might do an interview with you if there's an interesting public service story, like you write songs with veterans to help them with, overcome trauma. I mean, that you could probably get a local station or even a TV station to do a feature on you, but you're not going to get your songs played on radio. And so what you do is you build your own platform. You create lyric videos of your songs on your social media. You get on YouTube. You figure out how to work Facebook. You just can't post YouTube stuff up through Facebook. They want it to be posted natively in Facebook. So you figure out how that goes, and you work on developing your own platform. And you may only have a few hundred or maybe even 1,000 followers, but those 1,000 followers will share with their 10,000, 20,000 followers, and eventually you will be able to build an organic network that is almost impossible to do via radio. National radio promotion for a Christian single is usually $3,000 to $5,000 a month, and it usually takes 6 to 7 months to see if you even have a single that's going to hit. So it's really out. It's not. It's just, enjoy radio for what it is. And
but there are more avenues than ever before to get your music heard. It just may not be on those traditional K-Love type radio stations, is what you're saying. There's many
absolutely.
opportunities, especially on Spotify these days, to really do some independent pitching and promotions and getting on playlists and good curator playlists, etc. That's a whole nother course and curriculum that we've got for people that Dave Taylor teaches. So awesome. Last question, then we'll wrap this up, guys. Thank you so much for staying on, Vince.
Thank you.
Thanks for everybody for listening and contributing. It made it really fun. If Elaine says, if I add a melody to words written as encouragement, from example, words written by Joyce Meyer, are there copyright issues? If so, what do I need to do?
Yes. Now, again, something is only protectable after it's been committed to a reproducible format. So if Joyce Myers says something and her radio show has recorded it, or she's written it in a book, then it is her intellectual property. And for you to use that will require that you contact her or her publisher and say, I want to use a lyric that is inspired by something you said. Now, again, with respect to what is copyrightable, ideas aren't copyrightable. You and I were there when Bob Carlyle wrote this song called Butterfly Kisses. Yeah. So that song sold 2 million copies, but anybody could write a song called Butterfly Kisses, and anybody could write a song about a father's love for his daughter as she grows up. It's not the idea, it's the unique expression of words and melody that make it copyrightable. So if Joyce Myers writes about an idea, you can write another song about that idea. But if you use a number of words or a poem that she's written and commit that, then that's a derivative work, and you'll need permission of her or her publisher to do that. Yeah.
And usually that's right there in the book, and there's contact information for requesting if it's in your song and you're planning on releasing it in some way or another.
I mean, you could actually ask her for gratis permission. Would you allow me to use this at no charge?
Yep.
And she just might.
Yeah, I release instrumental piano music, and I get tons of requests, and I'm more than happy to do that for like YouTube videos or whatever, just a gratis use. Just credit my company, credit quiettimemusic.com in the credits or in the video. I'm usually really happy about that because we usually find people order that way, and there's other ways of receiving revenue. For me, that's just kind of
and or link to your page, So those are all things that would be helpful. That has value.
All right. Well, man, Vince, we went into it and battled this whole thing through. Again, for those of you that are still on, How to Make a Living in the Music Business is the book. Musicbusinessbasics.com. Sign up for the free newsletter that you release every month. It's very entertaining to read, actually. I really enjoy your monthly newsletter.
I get on some rants about stuff, and I think that's what you enjoy.
I like it. The book is an excellent resource, though, if you want a reference for today's music industry, especially for songwriters. And then if you really want to dive in, go ahead and get the course. Worship 10 is the coupon code, giving you 10% off of the individual modules or the total curriculum that's there.
And that's only good for a week. That discount's only good for a week. That's right.
So. It's good until August 31st or
25th.
25th. Okay.
I'll make it whenever you want to. I think it's a week from today, the 25th. Yeah.
Okay. Week from today. So take advantage of that. All right, Vince, really appreciate you. Thanks everybody for being a part of this. And
thank you. You guys have made my day.
Yeah. No, you've made us. They're all saying thank you. All right. We'll see you soon. Take care, Vince. Bye, everyone. Be safe.
Eric. Appreciate it. Bye-bye.